Hello everybody, just wanted to post this video that we're going to see of Drizin.
Welcome everyone. I'm Martin Pritikin. I'm the Dean of Concord Law School at Kaplan University, and this is the latest in our webinar series, our Distinguished Speaker webinar series. It will actually be the last one of our webinar series done under the auspices of Concord Law School at Kaplan University, because by the next time we do one of these, we should officially be part of the Purdue University system, and we will be known as Concord Law School at Purdue University Global. We are still an online school, but we will expect to have a change of ownership. Now, we're very fortunate to have with us here Professor Stephen Drizin. He's a clinical professor of law at the Pritzker School of Law at Northwestern University. He's also the co-founder of their Center for Wrongful Conviction of Youth. So I guess once we're part of Purdue, we'll have a Pac-10 rivalry, but for now, it's all copacetic. Stephen, thank you very much for joining us today.
It's a real honor and privilege and pleasure to be here.
Thank you very much. Now, you may all be more familiar with Professor Drizin as an attorney for Brendan Dassey, who is one of the individuals featured on the Making a Murderer documentary on Netflix, as well as certain other clients he's represented who've been the feature of documentaries. So today we want to talk to Professor Drizin about his work with his clinic, his work representing wrongfully convicted youth, and his work advocating for changes to the policing system and the criminal justice system to try and make it less likely that these things will happen again. So, Stephen, let me start off by asking you. Now, this is somewhat of a niche field. How did you get into this field of wrongful convictions, and specifically wrongful convictions of youthful offenders?
I'm a clinical professor of law, which means that I'm part of the law school curriculum where students work on live client cases with their attorneys, where they learn to become practicing lawyers. And very early on in my career, I was asked to represent an 11-year-old boy who had confessed to murdering his 83-year-old neighbor. And the first thing this 11-year-old boy said to me when I met with him was, "I said I did it, but I didn't do it." And even though he was 11, I could not understand how somebody could confess to the most heinous crime on the statute books, a crime that could send someone to prison for a very long time, and how he could do so in such detail. So from that moment, in January of 1995, I became obsessed with wrongful convictions and false confessions of young children. And I went on a sort of an intellectual odyssey, if you will, talking to all the experts, reading all the articles on the subject, going to police interrogation trainings and reading their manuals, all the psychological literature. And there wasn't as much then as there is now.
Right.
And I became somewhat expert in this area. And it took me 7 years to get that young man's conviction vacated in federal habeas in the Seventh Circuit.
So let me just ask about your background a bit. So was it common for you to represent youthful offenders, but not in this type of case? So you were sort of a juvenile advocate and sort of fell into this piece of it, or were you more on it from the criminal side and fell into the juvenile part of it?
I was on the juvenile side of it. My director, the director of the clinic, Tom Garrity, hired me out of private practice to work for 3 years on a fellowship to represent juveniles charged with the most serious crimes in criminal court and in juvenile court. Our main focus was on trying to keep kids in juvenile court, kids which the state was trying to prosecute as adults. And we represented a number of these young men and women. But this was the first case involving a false confession that crossed my desk.
Interesting. So, and by the way, just for the audience, if you have questions, feel free to type them in. I can't guarantee we'll get to all of them because we'll probably have a lot of them, and there's lots we want to ask about. But time permitting, we'll try and weave in some audience questions as well. So Steve, though, let me ask you this. So Once you founded this clinic that focuses on wrongful convictions of youth, how do you get your cases? How do you screen them? How do you decide which ones to take?
Deciding which cases to take is the hardest part of my job, because we get between the Center on Wrongful Convictions of Youth and the Center on Wrongful Convictions, which deals mostly with adult cases, we get well over 200 letters a month.
A month?
And, you know, many of these letters involve desperate clients who have written to other innocence projects only to be rejected, or letters from family members who are desperate to be reunited with their sons and daughters. And it's hard to decide which cases to take. I mean, my focus is primarily on false confession cases. So there are certain things that I look for that are red flags for me. Is there any physical evidence that was untested at the time of trial that I can test that could prove the confession false? Fingerprints, DNA, ballistics. Is there, were there tests done that excluded my client at the time of trial, but he was convicted anyway? Mm-hmm. Were there multiple false confessions in the same case? And were most of those confessions from juveniles or teenagers who are particularly vulnerable to police pressure? Do any of the suspects have intellectual disabilities, which also makes them more vulnerable to police pressure? The overriding question at the end of the day is there a legal pathway to relief, to victory? And it's often hard to tell that at the beginning of the case. So a lot of cases are sort of put in a pile, and they rise to the top later on. Many cases are easy to screen out because they're not cases where clients are claiming actual innocence. They were sentenced too long. Right. They were present at the crime scene but accountable in some way. But the other 50% or so are real hard to figure out. In fact, in several of our exoneration cases, those very cases have been rejected by colleagues of mine.
Wow. So 50%, I mean, would you say that 50% of the letters that you get, you really have to give it a hard look, have a hard time telling whether it's obviously not something that would fit with your clinic?
I would say about 50% are easily, you know, you're able to separate the wheat from the chaff. Mm-hmm. Then there's probably another 25% where with just a little digging, you can figure out this is not a case that's worth taking. But, you know, roughly 25% require much more intense digging and investigation.
And so you're talking about if you get 200 letters a month, you're talking about maybe 50 a month that you really have to give a close look to.
Yeah. Now, we have a number of attorneys in our center, so we can parcel them out among each other. Yeah, that's exactly right. I think that number is probably lower today than it was when we got started because most of the DNA cases have there's still some left, but in many of them, testing is now done as a matter of course during the investigation phase. So it's rare that you would have a murder or a rape case go to trial today where that testing wasn't done.
Right, right. And about what percentage of the cases would you say involve at least claims of false confessions?
Well, I come from Chicago, which is the false confession capital of the world. We've had dozens and dozens of false confessions here in Chicago, and I have a particular focus on false confessions. But I would say, you know, close to 40% of our requests that I look at involve false confessions, maybe more. And
I assume there's probably not statistics, or at least, you know, reliable statistics about the rates of false confessions. Is it a significantly more more frequent problem in juvenile cases than adult cases, or are there any numbers on that?
Yeah. The best data we have is to look at proven cases of actual false confessions. And the two data sets are the Innocence Project DNA database of all those who've been exonerated by DNA evidence, and the National Registry of Exonerations database, which includes both DNA and non-DNA cases. And if you look at the subset of false confessions in those databases, you see that juveniles are overrepresented in those databases. In the most recent numbers from the National Registry, there are 4 times as many juveniles who have falsely confessed as adults.
Wow.
Who have falsely confessed.
Wow.
So it's significant. It's a significant vulnerability. And I would say the other vulnerability is some type of intellectual disability. So in Brendan Dassey's case, you had a double whammy.
Right.
You had 2 vulnerability factors.
Right. And we're definitely going to be asking questions about Brendan Dassey. We actually have a question from the audience, which I think is fitting. You mentioned you have a fairly large team of lawyers who are screening cases, working on cases with your clinic. What are the sources of funding for the clinic? Do you have to seek grants? Is it funded through the university? How do you have the funding for such a really labor-intensive project?
Well, we don't have that large a group of attorneys. So in the Center on Wrongful Convictions of Youth, it's myself, Laura Nyrider, who Making a Murderer fans know, and Megan Crane, who is a terrific young attorney who we hired pursuant to a grant. We had to go out and seek soft money to hire her, and her grant runs out relatively soon. So fundraising for our center is particularly, it's a good part of what Laura and I try to do. So it's a mix of money that the university gives us to pay for my salary and Laura's salary, and then for Megan, we have to go raise that money. The same thing goes for the Center on Wrongful Convictions. Some of the people in that center are paid for by grants, by private donations, and some of their salaries are covered by the law school.
Oh, this is a real mix, trying to make sure you can maintain the funding for it.
Yeah.
Now, you mentioned certain groups being vulnerable, obviously juvenile offenders, those with mental disabilities. We actually have an audience question I think is fitting here. Are there any socioeconomic groups, racial, ethnic groups where you find that there is a higher rates of false confessions? I don't know if there's been analysis done of that.
I haven't done that analysis. I think you tend to have a much higher percentage of African American and Latino defendants in the false confession conversation, because those are the populations here in Chicago primarily where the Chicago Police Department have focused their efforts on solving crime and have obtained dozens of false confessions.
Right.
But that, their race or their socioeconomic status doesn't make them any more or less vulnerable than someone who is white, who is female, who comes from, a middle class or upper middle class background. Mm-hmm. The process of interrogation, especially coercive interrogation, can break down people of normal or even high intelligence given enough time.
Well, yeah, so let's get to the heart of the matter. I mean, you said that when you first encountered that 11-year-old client and you didn't believe he could have falsely confessed to such a heinous crime. You've come through research and experience to see that it actually is a prevalent problem. So what are some of the reasons why someone would falsely confess? I mean, I think to myself, I would never confess to a crime I didn't do, especially something as serious as murder. So how does it happen? And how does it seem to happen again and again and again?
Well, let's talk about two sides of that equation, because you look at two things whenever you're looking at those reasons. One are the tactics that police bring to the table and sort of other external factors like the length of time of the interrogation, the time of day. You know, it's no secret that police officers often conduct interrogations in the late evening hours or the wee morning hours, especially in murder cases. Mm-hmm. These are times when suspects are most likely to be tired, hungry, exhausted, and sleep deprivation is a risk factor for false confessions. And then you have the internal factors, the suspect's own personal vulnerabilities that make them more likely to falsely confess when pressured by the police. Youth, mental disability, mental illness, any type of character of personality that makes someone compliant, suggestible, a follower, naive, trusting in law enforcement. Mm-hmm. All of those are risk factors, as well as a lack of experience with the police. Until you've been in an interrogation room at the center of a murder investigation, you have no way of knowing what kind of pressure gets brought to bear on you. And that's why when people tell me I would never confess to a crime I didn't commit, I would never make that statement, because I have seen people with my background, given enough time and enough pressure, who break down and confess to crimes they didn't commit.
Now, I don't know if this is something you've encountered, but I remember reading an article in the New Yorker last year about a case, multiple cases involving people who not only confessed to crimes they didn't commit, but actually came to believe subjectively that they committed them, when in fact they hadn't. Is that something that you've encountered in your cases?
It's the rarest kind of false confession. It's called a coerced persuaded or a coerced internalized confession. And what happens in those cases is that the suspect comes to doubt their own memory.
Yeah.
Over time, after being told that there's a ton of evidence against him, which is a lie, oftentimes it's false. Police are allowed to lie about the evidence they have against a suspect. When they are told that they're guilty, when their assertions of their innocence are interrupted, when they are given two choices, both of which imply that the suspect is guilty, but one of which implies maybe they're less morally, culpable than the other. You were a witness, not a suspect. You were a lookout, not the person who pulled the trigger. Suspects will confess to crimes they didn't commit. Now, the kind of confession you're talking about usually involves suspects who enter the room with some reasons for doubting that their memory might be compromised. Perhaps they've had a blackout before. Perhaps they're alcoholics or have a drug abuse problem. So they already have some belief that their memory is not up to snuff. And when police officers suggest to them that it's quite common that people confess to things and either repress those memories or don't remember or commit them in some kind of a fugue state, they actually come to accept that fact. In these cases, police get the suspect to close their eyes and search the deep, dark recesses of their memory to come up with images, and then they manipulate those images so that the suspect actually thinks those images are his own. In fact, they are planted by law enforcement through their questions. So it happens. It happens rarely, but it does happen.
Well, so let me ask you the flip side of the question about why people falsely confess. Why do police entertain those confessions? I mean, obviously we know police want to solve crimes, right? But I mean, just like I think to myself, I would never confess to a crime I didn't commit, I also think to myself, if I was a police officer, if I grilled someone for 16 hours straight and they were sleep deprived and hungry, and I had been feeding them leading questions for hour after hour after hour, and they deny, and finally break down and admit they did it, I would be concerned that that wouldn't be persuasive evidence in court, that I couldn't get a conviction based on that. So, you mentioned Chicago is the false confession capital of the world. Is it because some places have more bad apples than others? Is it something about police psychology? Why do you think police are inducing these confessions and actually going with them?
I think it's a mixture of both. I think there are a number of bad apples. Chicago has had a police torture scandal in my lifetime. So there was a culture among some in the detectives unit to get a confession at all costs. But the more common reason is just police tunnel vision. For whatever reason, they lock in on one particular suspect early on in the investigation. Maybe the suspect was a relative of the victim. Maybe the suspect was the last person to see the victim alive. Doesn't matter whether that's evidence-based or more based in gut or hunch, but the more that that suspect denies guilt, the more that police see that as evidence of guilt. And a confirmation bias begins to take hold. So police officers who are focused on a particular suspect lock in on that suspect, and they ignore their assertions of innocence, they ignore the red flags, and they finally break down the suspect into getting the suspect to confess. Now, once you get a suspect to confess, the game's not over. And the most important part of the interrogation is getting that suspect to confess to details of the crime that match the objective evidence that the police have gathered, details that only the true perpetrator would know. What we see in Chicago and other police departments that are not well trained is that the police officers feed those facts to the suspect. They have a preconceived theory of how the crime occurred, and they force the suspect into adopting a set of facts that fit that theory. And oftentimes it's DNA evidence that shows that theory was wrong to begin with.
Right. And I was going to say, we clearly saw that with Brendan Dassey's videotaped interrogation, at least the portions that we saw in the documentary.
That's right.
Now, you mentioned that juvenile defendants are more susceptible to being coerced into false confessions. I wonder, though, and this is actually an audience question, I think it's a good one, what are some of the particular challenges of having a youthful offender as a client? I mean, I know just clients in general can have their challenges to work with, but I assume it's got to be particularly difficult with youthful offenders. Can you comment on that?
It is. I mean, it requires more work, I would think, more hard work, more face time, more involvement on the part of our students on a regular basis with the crime. You have to build a rapport. You have to build a trust. You have to show the client not only that you care about them, but you're willing to fight for them. And it often takes more time in explaining the basic concepts of a criminal case and what's going on in a courtroom and the meaning of legal terms. So there are a lot of challenges with representing this population, but I think that it's fun. I enjoy it very much.
Now, how many, through your clinic or otherwise, how many cases are you handling at any given time? And is there a rough average as to how long you end up working on a single case?
I think that the number of cases we're handling at a given time has gone down in recent years because the Brendan Dassey case has taken a tremendous amount of time. So we've limited our intake a bit, but I think generally we like to have between our three attorneys 25 to 30 cases at a time, and then the Center on Wrongful Convictions has even more. These cases are both post-conviction cases where we're doing new investigations to find new evidence of actual innocence. Some of them are appeals. Some of them are amicus briefs that we write in other people's cases. Some of them involve myself working as an expert on a case and consulting with other attorneys. But I would think that when we're, clicking on all cylinders and we don't have a case of the magnitude of Brendan's case, that we would like to have between 30 and 35 cases at any given time.
That's very impressive. Well, let's talk a little about Brendan's case and also, I mean, we mentioned Making a Murderer, we mentioned, David and Me, West of Memphis, obviously other high-profile cases, the Central Park Five, another documentary, Long Shot, slightly different issue there, obviously. Why do you think there's this cultural fascination with wrongful convictions? The podcast Serial, I mean, well, it's debatable if it's wrongful, right? But I mean, the list go on and on. Why do you think, is this something particular about this moment in American culture? Why is it that it captures people's fascination, the idea that there may be people out there who are wrongfully convicted?
I just think that the innocence movement, which arguably began in the, late 1980s with the development of DNA evidence and the Innocence Project's early work, although there were other Innocence Projects before then. Centurion Ministries was actually the first Innocence Project in the United States. But the Innocence movement has made this issue palpable to everybody in the general public. And it has really shocked people, and it has caused them to question what had been, a pretty blind faith in the accuracy of our criminal justice system. Mm-hmm. And the stories themselves are just so compelling because they take a long time to get the evidence to open up someone's cell doors. You see pushback, tremendous pushback from law enforcement and from prosecutors. And you see a system that wants to keep convictions in place, oftentimes at the sake of concepts like truth and justice. So I think each one of these cases provides an incredibly compelling human narrative and an indictment on the way that our legal system works. And that's why I think it's so compelling.
It's very interesting. Well, so let's turn to Brendan Dassey's case for a few minutes. So how did you come to be a part of this case? Was it through the normal screening process you described as part of your clinic, or did it come through a different way?
It was through a different way. I have been working on false confessions involving juveniles, and I had been asked to work on a case in Wisconsin of a young man in Milwaukee who claimed that he had falsely confessed to an armed robbery of a McDonald's. And I worked on that case with the lead attorney, and the case went all the way up to the Wisconsin Supreme Court. And it was a case where we argued that it was time for Wisconsin to require that police electronically record all interrogations of suspects. And we won. In 2004 or 2005, the court gave a beautiful opinion that focused on the particular vulnerabilities of young people and required that all interrogations of juvenile suspects be recorded from then on out in Wisconsin. And this was right around the time that Brendan Dassey's case first hit the news,
right?
Which everybody in the innocence world knew because, of course, Stephen Avery had been a cause célèbre of the innocence movement because he had been exonerated by DNA evidence, and then he was tied up in this investigation. And so the lawyers who I worked with on the first Wisconsin case and a group of other lawyers who I respect from Wisconsin called me up and asked me if I would represent Brendan on appeal and in his post-conviction case. And I said, of course, I would. And the funny thing about that is that I assigned that case to my then student, Laura Nyreiter, who, got so involved in and so compelled by what she saw when she watched that videotape that she could never let go of it. And I eventually hired her. She eventually became the lead attorney on appeal with me. She argued the cases in the Seventh Circuit. And so it was a double blessing, if you will. We got to work on a fascinating, exciting case, but I got to work with and develop, a new superstar young attorney in the process.
That's great. Now, I've seen the documentary season 1. I saw the clips they showed of the interrogation. Would you say that's one of the more egregious cases you've seen of coerced confession, or is that along the lines of what you see in other cases?
It's not one of the most egregious. I mean, I've seen in my experience many interrogations, even interrogations involving juveniles, where the police threaten the suspect with the death penalty.
Wow.
Tell them that they want to hang him from the highest tree, or, the state is ready to stick a needle in their arm. I mean, real over-the-top kinds of interrogations. I've also seen cases where there's evidence of physical abuse. Brendan's case is important because it is a more common kind of interrogation where subtle, more psychological pressures are brought to bear on a suspect. And what the lesson is from Brendan's case is that these tactics, either individually or cumulatively, might not be deemed coercive if the person in the box was an adult or someone of normal intelligence. But when you use these tactics on someone like Brendan, who is young, inexperienced with the police, naive, compliant, and suggestible, then you run the risk of getting coerced and false confessions.
Now, how much, if at all, did you interact with or coordinate with the documentary makers as the case was proceeding, at least for season 1? Did it impact things, or were they really just more in the background?
They were in the background. I mean, when we went up to Manitowoc, Wisconsin, it was brutal. It was like in January. I mean, it were sub-zero temperatures and snow had been on the ground for months. When we went up there for a week and we went into court, there were these 2 filmmakers, independent filmmakers. They didn't have any backing. They had put together this film on their own. One had sort of left her job as a lawyer and was working as a contract lawyer to help keep the project afloat.
Wow.
And they were just there filming, which was terrifying to me because we don't have cameras in our courtroom here in Illinois. This is the first time we've tried a case on camera.
Wow.
Now, after a while, you don't remember that the cameras are there. We cooperated with them to the extent that we were cooperating with everyone else in the press and talking to the press. But we didn't have any reason to think this film was ever going to be made. And in fact, it took another 4 years or more before they got the financing from Netflix to complete the film. So I was as surprised as everybody else, maybe a little less surprised because I saw a sneak preview a couple of days before the release.
Mm-hmm.
And I'm kicking myself for not buying Netflix stock. But I was stunned when that series came out because I had no idea how they were going to put together that story and to do so, especially with regard to Brendan's case, in such a powerful way.
Now, I know that there was a lot of controversy when the documentary came out about claims the documentarians sort of skewed things and didn't present all pieces of the puzzle. To the extent that you can talk about it, did you feel that it presented a fair portrayal of the evidence, at least with regard to Brendan's case?
Unquestionably with regard to Brendan's case. Look, Brendan's case is fairly straightforward,
mm-hmm.
and it's all on tape, right? At least it was until we got in the case and we realized there was this whole backstory with Brendan's attorney.
Right.
But most of Brendan's case is about what's on tape during his interrogations. Through the post-conviction process, we discovered that his own attorney, Len Kaczynski, was ineffective and essentially sold him down the river and
Right.
used his own investigator to coerce yet other confessions from Brendan. But they portrayed Brendan's case very fairly, very accurately. And I think the public, when they saw these tapes, they were stunned that police could do that with a child without a parent present or a lawyer present, and especially with someone who was clearly disabled, clearly not anywhere near on the same playing field as the police.
And so, and I can't recall exactly how much of the tapes of the interrogation were played to the jury, but I mean, in light of those tapes, seeing what I saw, were you shocked that a jury would convict on that basis?
I was not shocked, only because I think that his defense lawyers didn't do an adequate job of highlighting all of the instances of police contamination. Mm-hmm. That confession really wasn't Brendan's confession at all.
Right.
It was the product of his police officers' imagination, and they pressured Brendan to accept their storyline, even though that storyline was not backed up by any physical evidence, any DNA, any hairs, any blood, any fingerprints, anything.
Right.
But even had they done a better job of highlighting the contamination, it's very difficult for jurors to get over the hump that you asked about at the very beginning of this interview. Why would anyone confess to a crime they didn't commit? Dean Strang and Jerry Buting, who were Steve and Avery's lawyers, had hired a false confession expert to analyze Brendan's confession. And he was already paid for, he had already done the work, and he could have helped that jury understand why this confession was coerced and unreliable. And for whatever reason, Brendan's attorneys didn't use them.
Wow.
I think that was a big mistake as well.
Yeah. Well, so different people watching may have different familiarities with where things are procedurally with Brendan's case. I think when the documentary ended, he had been convicted. Can you catch people up as to sort of where things left off from the end of that season and where things are now with this case?
So after the documentary concluded season 1 of Making a Murderer, Brendan is convicted and sentenced to life with the possibility of parole beginning in 2048. And then Laura and I get involved in the case, and did our post-conviction petition, and the hearing was held, and relief had been denied. After relief was denied in the state courts, we then pursued relief in the federal courts through federal habeas. Mm-hmm. And we won, which was a miracle.
I remember reading about that in the news, yeah.
We won in the federal district court on the ground that Brendan's confession was not a voluntary confession. The state appealed that decision. We won in the Seventh Circuit in a 2-1 decision, which was another miracle. Both of these victories were against extremely long odds. And most recently this fall, in an en banc decision of 7 judges of the Seventh Circuit, they took away that victory, and they vacated the decision granting Brendan a writ by a 4-3 vote. So now where we are is we are petitioning the United States Supreme Court for a writ of certiorari so that they will review the en banc court's decision.
And I should mention for the audience, Steve is not just tooting his own horn when he talks about those being miracles. For those of you who don't know, habeas corpus petitions are almost never successful. It is statistically a huge outlier for any of them to be granted. So to win twice really is quite remarkable. And then to have that victory snatched away by the closest margins with the en banc rehearing is really tragic. Steve, if you could, can you tell the audience a little bit about how close Brendan got to actually getting to be out of prison during these post-conviction proceedings?
So after we won in the district court, we waited a while and we got our social worker involved at the clinic, and we put together a release plan for Brendan that we felt would assure the district court that there would be little risk to letting Brendan out on bond. And we filed a bond motion, and the court eventually granted that bond motion for Brendan, and he was about ready to get released. The media trucks were all around the prison. His family had made the preparations, and the state sought an emergency stay of the district court's order, and the Seventh Circuit granted that stay. So he came within a few hours of seeing freedom. And we lost 4-3 in the most recent round of decisions with the Seventh Circuit. And I'm convinced we would have won that decision. It would have been a 4-4 decision, which would have meant that Judge Duffin's opinion would have stayed in force, the district court's opinion. But, out of the blue, one of the justices on the Seventh Circuit retired on September 1st. And we knew going into that argument in late September that our chances of winning were remote at best.
Right.
And we felt we had a good shot at getting Judge Posner's vote. We'll never know.
Right.
But it's disappointing that this case, may have turned on the decision of one judge to retire.
Wow. And what kind of toll has that taken on Brendan? Does he understand how close he's come so many times and what a seesaw this has been? What does that do to someone?
It's hard. It's very hard. One of the hardest jobs that Laura and I and our students have had is managing Brendan's expectations. And I think we've done a pretty good job of it. I mean, we've told him every step of the way that we thought that win or lose, this case was going to end up in the Supreme Court. That doesn't mean the Supreme Court is going to take the case, but we're going to get to the Supreme Court on this case. So to try to keep his emotions stable until the final lap.
Wow. Now, I mentioned the toll on Brendan. What about you or the colleagues you work with on this case or others? I mean, in my background in practice, it was mostly civil litigation where there was money at stake, and even if it's a lot of money, it's still just money. How do you cope with the psychic burden of knowing that your client's freedom is on the line with these cases that you're fighting, which are often an uphill battle?
It's hard. It takes a very strong emotional toll on the lawyers involved. But whatever we're experiencing is really nothing compared to what the client is experiencing and the client's family.
Sure.
And at the end of the day, while we will continue to fight in whatever way and in whatever venue we can to get Brendan's relief if we lose, we have other clients and other cases that we are committed to representing, and we will have to use the successes that we've had in those cases to sustain us.
Yeah. Wow. Well, Steve, you mentioned a couple of times season 1 of Making a Murderer, which makes it sound like there's going to be a season 2. Is that so? And if so, we saw it for the trial. So what's going to be in season 2?
I think season 2 is going to just pick up where the story left off. I mean, I don't know that for a fact, but I think, and this is what I'm excited about if it's done as well as season 1, is it's going to give the public an in-depth view of a process that is largely unknown to them. The post-conviction process, the appeals process, the investigation into a claim of actual innocence, the legal strategizing about how to formulate the claims that might bring relief, and oral argument when the cases are before courts of appeal. This part of the practice is rarely captured in documentaries, and I'm hopeful that it will shine a bright light on the kind of work that Laura and I and other innocence projects are doing around the country.
That's great. Now, obviously, part of that process, you hope, is arguing your case before the Supreme Court, given the context of Brendan's case. Can you talk a little bit about sort of the dynamic of getting in front of the Supreme Court and who gets involved in that? Sure.
So when we knew that this case was going to the Supreme Court after the en banc decision, Laura and I had a decision to make. And it was a pretty easy decision. The decision was, what's in Brendan's best interest? And the decision boils down to, do we argue the case before the U.S. Supreme Court, or do we partner with more experienced Supreme Court litigators, people who have argued dozens of times before the court, former solicitor generals who are well known to the justices? Mm-hmm. And it became clear to me, both from prior experience and from some of the comments of some of the justices recently who have said that they think it's akin to malpractice to not have a seasoned litigator arguing before the court, that we needed to partner with more experienced Supreme Court litigators. And we have partnered with the best, somebody who's argued before the court dozens of times. I've worked with him in the past. He and his group of lawyers at his firm are some of the best and the brightest Supreme Court litigators in the world. And I'm very excited at the fact that in a few days, when our brief is filed, the world will know that we've done everything we can to get only the best for Brendan Dassey.
Well, that's great. And I look forward to finding out who exactly that is. I'll be looking for the press on that. Well, let me switch gears a little bit. We've got about 10, 15 minutes left, and I want to talk not necessarily about your representation of individual clients, but your advocacy for reform. What are some of the principal reforms that you think that police departments, prosecutors should be adopting to try and avoid these problems of false confessions, and in particular false confessions with youthful suspects?
So one of the things I'm most proud of our center is that in addition to working on individual cases and exonerating more than a dozen people, especially if you include the co-defendants of those we represented, we also write legal scholarship that has been cited by other courts. We train other lawyers in how to represent clients in these cases. And we seek and advocate for reforms of the process to prevent false confessions from happening. With regard to that last area, the reforms, we were very active in Illinois in making Illinois the first state in the country to pass a law requiring that all interrogations in homicide cases be electronically recorded. That happened in 2003, even before our center was born.
Wow.
And that became enacted in 2005. Previously, a couple of Supreme Courts had required police to record interrogations, but this was the first state legislature that had passed a law requiring it. Mm. And since then, we've been involved in efforts around the country in other states. Wisconsin, we talked about, where we got the Wisconsin Supreme Court to require it. And today, what was once 2 states is now close to 25 states.
Wow.
25 states in this country now require some police interrogations to be recorded. either audio or video. And so we have another 25 states to go, but that's a huge sea change in a short period of time. And we're proud to have worked in some of those states to make that happen. The other reforms have to do with the presence of counsel for kids. In a number of cases that we've relied on in our pleadings throughout Brendan's case, from the U.S. Supreme Court, the Supreme Court has stated how important it is for a child to have adult guidance during the interrogation process so that he understands his Miranda rights and knows the consequences of waiving them, so that there's a witness to the kinds of pressures that are brought to bear. Sometimes it can be a parent, but the court also spoke about lawyers and counsel for kids. And we've been able here in Illinois to break open that interrogation room door by working with other groups and getting one of the first laws passed in the country to require that for youth under the age of 15 in certain serious cases, they now have to be represented by counsel or have a meaningful consultation with counsel before they waive their Miranda rights. Most recently in California, a similar law was passed, and we were involved in that effort with Human Rights Watch of California, and that was signed into law by Governor Jerry Brown in September. So California now has an even broader mandate. If you're under 16 and you're charged with serious crimes, you can't waive your Miranda rights before talking to an attorney.
Now, I know this is purely speculation, but do you think there's a prospect that at any point the U.S. Supreme Court will say it's a constitutional mandate that every state offer these protections for juvenile suspects?
I think it's unlikely, but I think what is more likely is they will consider again the lack of an adult, the lack of a lawyer, or the failure to videotape as important factors in determining whether or not a suspect's confession is voluntary or reliable.
Right.
The other thing that we've done is work with police interrogation trainers and police departments to try to change the way they interrogate suspects, both juveniles and adults, to try to get them to understand that if you lie to children, if you give them only two options, a forced choice, neither of which is a good option, both of which require that they say they're guilty. If you promise leniency or threaten harm to suspects, if you feed them facts, okay, that's a recipe for disaster with children. And we have been effective in working with law enforcement to get them to realize that confrontational, accusatorial tactics with children are the wrong way to go. And we're seeing the beginnings of a revolution in the field of interrogation training where different models of interrogation are coming in. And some of the old models, like the Reed technique, are no longer the models of choice.
And let me ask, are you getting any pushback from any departments saying, hey, you're trying to take away our most effective tools to getting genuine confessions, or have people been more or less receptive to these ideas?
There's been pushback at every step of the way. I mean, I can't tell you some of the ludicrous arguments we heard about videotaping, 10 or 15 years ago. But by and large, it's been the experience of police departments with electronic recording and seeing how it makes their cases stronger and it makes it easier to get convictions, and realizing that jurors will cut them some slack with regard to some of their tactics as necessities in order to get a truthful confession, that by and large, most police law enforcement agencies in the country today recognize that recording is an important investigative tool. Even in the 25 states that have not yet passed a law to require a recording, in many of those states, police departments are doing it on their own. So yeah, there's pushback. There's inevitable pushback.
Yeah.
But when you use police officers to do the pushing on our side of things, it helps to open the minds of other police agencies.
Right, right. Now, what can people do? I mean, obviously, you hear about cases like this, your sense of injustice and outrage, it just rears up. There's probably a lot of law students, maybe lawyers who are in the audience right now. If someone wants to get involved, either on the advocacy side or if they actually want to get involved on the representation side, what are some of the things that people can do to try and help?
So we work with a lot of private law firms on our cases. We often partner with them on some of our cases. And so if you're an associate at a private law firm or just out of law school and you want to do pro bono work, give us a call. We'll find an opportunity for you to do work on some of our cases if one exists. If you're just a mother or a parent of a child who's been interrogated and you were cut out of the process, we will work with you and try to find local advocates who can be your voice in trying to get policies changed with regard to the way police officers interrogate children. If you want to contribute money to the Center on Wrongful Convictions of Youth, we're not going to turn that away either. But there are more practical ways for you to get involved by working with the politicians in your state who you think will carry the water for some of these reforms. We can't necessarily identify them, but you can. And remember, wrongful convictions are not a Democratic issue or a Republican issue.
Right.
I think everybody on both sides of the aisle does not want the wrong person to be locked up for a crime they didn't commit. Because when that person is locked up, that means that the real person is out, still available, ready, willing, and able to commit crimes.
Absolutely. Now, I know there are a number of different innocence projects around the country. Is there any national directory or clearinghouse or central organization that tries to coordinate those efforts or, compile them so that people in different parts of the country can access the resources they need?
Yes, there's an Innocence Network, which is a loose configuration of all the projects, not only in the United States, in regions of the United States, in individual states, but also in countries around the world now. It's a global movement.
Wow.
And the Innocence Network has its own website. I'm sure if you Googled Innocence Network, you'd get very quickly into the kinds of resources that are available in a state near you or a region near you where you can get involved.
Well, that's great. That's very helpful. We have one last question actually from the audience. Let's say that the Supreme Court of the United States doesn't take Brendan Dassey's case, or they take it on cert, and if unfortunately you're not successful, are there any last resorts, any next steps for Brendan, possibly down the road?
The only other alternatives for Brendan is if newly discovered evidence of actual innocence that identifies the true perpetrator in this case comes forward. There's a possibility that that evidence might come forward. I know that Stephen Avery's attorney is spending hundreds of thousands of dollars to try to find that kind of evidence. And if she discovers it, you better believe that Brendan's legal team will look closely at it to see if it's another way to get Brendan's case back in the court. Other than that, I think that the only options are to elect a more open-minded and progressive governor in the state of Wisconsin and then mount a clemency campaign to get Brendan out before 2048.
Right. Well, we certainly hope it doesn't come to that, but it's good to know that there's folks like you who are fighting for people, trying to get the right thing to happen. Well, Stephen, we have to wrap up. I want to thank you once again for taking the time to talk to me for the benefit of our audience. I'm sure it was as enlightening and informative for them as it was for me. For everyone in our audience, I want to thank you for attending and let you know that our next Distinguished Speaker webinar, we don't have the entire panel lined up yet, but we expect that in May we're going to be doing an event in conjunction with the ABA's annual Law Day. The annual theme this year is Separation of Powers, Framework for Freedom, which is a ripe topic to talk about issues like the potential for presidential impeachment, special counsel's investigation, and related topics. So keep an eye out for advertisements on that. Thank you to all of you behind the scenes who helped make this event possible, and we look forward to hearing more good things. In Brendan's case, we'll look forward to season 2 of Making a Murderer, and thank you once again for all your time.
Thank you. It's been a pleasure.
Take care, everybody.